You're listening to Rethinking Trade with Lori Wallach.
Small business owners and farmers are protesting the Korean WTO and NAFTA are transnational forms of autocratic governance that subordinate our
North American free trade agreement.
Seattle has never seen anything like it.
Mexican workers face threats of violence.
Trade policy has delivered one punch in the gut after another.
Welcome back to Rethinking Trade, where we don't just talk about trade policy, we fight to change it. I'm Ryan, and I'm joined once again by our in-house trade expert, Lori Wallach. So, Lori, last week we discussed the new North American Free Trade Agreement, the USMCA, and talked about the campaign to improve it. Anyone who followed the campaign knows that there's a lot that still needs to be done to make some of the deal's improvements real, especially on the labor front. So for starters, maybe you could just give us an overview of what some of those changes are, and then we'll get into how they might happen.
So the new NAFTA can be looked at as having two sets of changes. Bad things that were in there that got whacked, like investor-state dispute settlement, and then potentially useful things that got added, like the new labor standards, and perhaps most importantly, their enforcement through a system called the Rapid Response Enforcement Mechanism. And on paper, those new labor standards and enforcement mechanisms are definitely an improvement over the old NAFTA, which had a non-binding labor side agreement that, even if it was ever used properly, couldn't result in any real enforcement. The trick is going to be the enormous amount of pressure, campaigning, monitoring that will be necessary to translate these improvements on paper into improvements for workers' lives in Mexico or in the US. So the first thing to think about is what actually has to be done to set up this new mechanism and whether it's on track. And then second of all, what are the cases? How are we actually going to see things change on the ground?
So while we're on the topic of things on the ground, let's talk about two of the elephants in the room. And that's the case of Susana Prieto Terrazas and also the onslaught of lawsuits challenging Mexico's labor law reform that are now moving.
So, the way these things work together is that the new NAFTA required certain changes in Mexico's domestic labor law, which basically implemented changes made to Mexico's constitution in 2017. And among those things were guaranteed reviews of all existing contracts made by unions, because a lot of them are fake, corrupt protection unions that are basically their job is they get hired to protect the boss, and they've registered contracts that lock in low wages and bad working conditions. And so the new Mexican labor law and the new NAFTA require that in 4 years, every one of these old contracts has to be reviewed, either voted by the workers in a secret ballot vote to be continued or replaced with a real contract that represents workers' interests. And the new labor law requires the right to see the contract before there's a vote, which was not the case in the previous law. For the workers who are going to live under the contract, to get to approve it, which was not the case. A lot of these protection contracts are completed before the first worker's even hired. And then finally, the ability to have accountability over the union officials that workers elect with respect to budgets of the unions, etc. The thing that's very worrisome is there are now over 600 challenges in the Mexican court system against implementation of that new labor law. And they're almost all filed by these corrupt protection unions who cynically, disgustingly are claiming it violates basic workers' rights and the ILO, International Labor Organization conventions, to make these reforms that effectively implement the ILO conventions. The cases have been working their way up towards the Supreme Court of Mexico. At a certain point a few months ago, a body that is part of the federal judiciary system in Mexico concentrated all the cases in particular courts, and the Supreme Court, who knows when though, will decide. In the interim, the law is kind of on hold. It definitely doesn't apply to a bunch of the fake contracts that have effectively like injunctions against them, but it could be all thrown out as unconstitutional. Second problem is there is hands-on obstruction of these new rights, even when they are not under challenge. And that includes the case of Susana Prieto. So we've talked about the situation before. She was arrested under trumped-up fake charges of causing a riot relating to her excellent work to try and actually file in the labor court the certification of a new union that got rid of a fake old union. She's a lady who's very well known in Mexico because she's the person who helped workers get real wage increases last year in the border maquiladora factories in Juarez and Matamoros. She also helped workers fight to get COVID protections, safety in their workplace this year. And she was swooped up in jail. She was denied bail punitively, repeatedly. It was not safe, obviously, like in the US. Mexican jails have COVID issues. And then her third bail hearing was July 1st, the day the new NAFTA went into effect. And instead of having a bail hearing, the prosecutor said, "Have we got a deal for you? We'll let you out of jail, but only if you promise not to go back to the city where the workers you represent are and never go back to the labor court you would need to visit to file for their rights." And this temporary suspension of her arrest, it's sort of like a plea bargain, is how she is currently out of jail, but in a condition that is totally outrageous and undermines the ability for workers to have the basic labor rights, not just required in the new NAFTA, but provided for in Mexico's constitution and in their laws.
And can these labor abuses in the case of Susana Prieto, could those become a case under the new NAFTA?
Well, it's worth understanding a little bit about how that rapid response system works, a little bit of the nuts and bolts. The quick answer is yes, it probably could be. But the way this works under this system is that normally when you enforce a trade agreement, one country sues another country, it goes to a tribunal, it takes years to get to the end result. And then typically the enforcement is trade sanctions, tariffs against a country for violating a provision. Problem with that in the labor situation is the actual companies who are doing the bad stuff are not feeling any pain directly. So the rapid response system basically is set up so that a country, say the US, files a complaint with Mexico saying, hey, this situation with Susana Prieto is a violation of the following provisions of NAFTA. And given a particular company has been involved in, there's a particular company for which he was trying to file this new union, that company would be implicated. And then Mexico has a certain number of days to respond. And they can either say, hey, that's not what really happened, and try and make the US back down, or they can cure, they can fix the problem. Then the US, say if they're starting the case, looks at the response, neither says, okay, it's fixed, or I guess there's not a problem. Or the US says, not buying that. And then they file the next step, which is basically like a formal claim. It gets heard by a tribunal of labor experts, which is not the usual, trade lawyers make the decisions, which is good. It's much quicker. It's not quick, but it's much quicker than the normal years and years. And in the beginning, this tribunal has the right to go to Mexico to investigate, to interview. The Mexican government's required to provide them access. And then this tribunal can order, in the first instance of a violation, that the company, either directly, the company involved, be hit with trade sanctions or fines. And then if it's ongoing, they can have their products denied access into the US, just literally blocked at the border. So there is some real there. There are all kinds of curly cues of where things could go awry, and it's not super speedy, but it's like a 6-month process. So that could become one of the first tests of whether or not the new NAFTA's labor standards and enforcement have teeth.
And outside of the sort of official response mechanisms and monitoring efforts, maybe to close us out for this episode, you could talk about some of the ways in which labor unions, civil society organizations, progressive groups here can play a role in making sure that some of these new standards and requirements are respected and enforced.
Well, to quote Frederick Douglass, power concedes nothing without demand. So we are going to have to keep a really bright spotlight on the situation and have continuous pressure both on the U.S. government to take the necessary actions, but also with our partners in Mexico on the Mexican government to implement all of these commitments. And, our counterparts in Mexico are going to be doing their best to elevate these cases and fight for their rights. But it is only going to really be a successful use of the gains in the new NAFTA if workers and activists and, frankly, members of Congress in all of North America are united together trying to improve standards for workers throughout the hemisphere, which first and foremost starts with workers in Mexico finally having real rights to form a union and fight for better conditions and higher wages.
That's all for today. Thank you all for listening. Rethinking Trade is produced by Public Citizens Global Trade Watch. I would encourage you to visit rethinktrade.org as well as tradewatch.org to educate yourself and to find out how you can get involved in the work we're doing to fight for fairer and more equitable trade policies.